Welcome back, everybody, to our studies in the law of contracts. This lesson is going to be carrying on from the previous video on the subject of undue influence. The previous lesson fundamentally spent some time talking about the concept of actual undue influence, where you can actually prove that there existed a certain amount of exerted pressure which induces you into a contractual arrangement which you would not have otherwise had signed or otherwise had agreed to had that external pressure not existed. This lesson is going to be a little bit more detailed because we're going to focus on this idea of presumed undue influence. So the case of presumed undue influence are really established mainly in the case of Barclays Bank PLC versus O'Brien from 1993. And it noted here that there are actually two classes of presumed undue influence. We divide presumed undue influence into two classes, and these two classes are both discussed in the case of Barclays Bank. And so really, let's just begin from looking at that case. So it's a case from 1993, and it was a case where we have a defendant who had been the wife of an individual who had mortgaged the matrimonial home for the purposes of securing a business overdraft. This business overdraft had not been truthfully communicated to the defendant, and so as a result of which, when the husband had defaulted on the debts, the bank, i.e. the claimants, had sought to enforce this against the mortgage. The case went to court, as you can probably imagine, where the mortgage would be avoided. However, for the purposes of this case, what is important to note is that it was a case in which the courts discuss the concept of undue influence which is presumed, and the concept that undue influence which is presumed can be divided into two main subclasses, two main kinds of presumptive undue influence. So they first divided it into actual undue influence on the one hand and then presumed undue influence on the other hand, and then they went on to go and talk about the fact that there are two classes of undue influence, and the courts divide these into class 2A and class 2B. Presumed undue influence involves the person making the complaint, who is making the complaint, having to show a relationship of trust and confidence, a fiduciary relationship, in which it is presumed that the individual had acted in a way which amounts to an abuse of that fiduciary relationship, which then, as a result of which, will lead the claimant to entering into a transaction. When we talk about a class 2A presumed undue influence, there will be a necessity to show that a certain relationship exists. And then if you can show that this relationship exists, this quote special relationship, then this will automatically give rise to an assumption or a presumption of undue influence. In cases where it is class 2B, there will not exist this special relationship, and as a result of which, the person who is making the claim to undue influence will have to prove that there exists a relationship of trust and confidence, there exists a fiduciary relationship, and then from there it can be presumed that undue influence has been present. So, we're not going to get into all of the cases here, but a number of the decisions have been established in previous cases, which establish what these special relationships actually are, and which ones are actually special relationships. So, for example, a parent and a child relationship, a doctor and a patient, a client and a solicitor all represent this special relationship and have been established previously in cases to represent a special relationship. More importantly, therefore, let's spend a little bit of time talking about class 2B, the presumed special relationship, or where there is no presumption of special relationship. There are instances where there might exist a situation in which there is not this presumed undue influence on the basis of a special relationship. But as stated earlier, it will be up to the complainant to show that de facto there is a relationship of trust and confidence. When we refer to the relationship that is being had between a husband and a wife, as is the case of Barclays Bank, for example, or potentially that of the relationship between the banks themselves and the clients themselves, which is a case that you can see in the case of Lloyds Bank PLC and Bundy, these are both examples in which you can try and present the case that there exists a relationship of trust and confidence, that there exists de facto a relationship of trust and confidence, at which point we can then come to a conclusion about Class 2B presumed undue influence.